Good evening, everyone. You're all very welcome. It's really a wonderful evening and delighted to see you all here. It's really a great personal privilege to welcome Dr. Robinson here this evening to the School of Law and to the Irish Centre for Human Rights at NUI Galway. As with many of you here, I've always been a great admirer and been lucky enough to have been inspired over many years by her activism and advocacy on behalf of Manona Heron, but of course all of us here locally and globally. So we couldn't have brought a better advocate to speak to you tonight on the topic, the necessity of advocacy and the continuing necessity of advocacy. Dr. Robinson, Judge O'Connor, Judge MacDonald, colleagues from the judiciary, friends, students, we're delighted to welcome you here this evening. This event is organised at a time when populism appears to herald what has been talked about as a politics of dark times across Europe and, of course, globally. And it is timely, therefore, in Ireland to reflect on how political activism and advocacy can also bring us constitutional transformations and human rights movements that are rooted in respect for autonomy, dignity, and equality. This year, of course, marks not only the 70th anniversary of the Universal Declaration of Human Rights, but also the 50th anniversary of the Civil Rights Movement. And our own late Professor Kevin Boyle, of course, was a leader in the civil rights movement, and I'm sure would have been troubled by some of the developments today around Brexit and around the legacy and troubled legacy of the Good Friday Agreement at the moment. Against that background, however, in the last 12 months alone, we have witnessed significant constitutional change here in Ireland. Landmark court judgments on the right to work for asylum seekers, rights to family unity for migrant families, and a constitutional recognition of the right to an environment that is consistent with human dignity and well-being as an essential condition for the fulfillment of all human rights. These changes are brought about by all of us by engaging in processes of legal and political change and transformation that are often risky and unpredictable, and at times bring with them significant personal cost to those most affected. We are reminded through these changes, however, of a politics of the possible, what can be achieved. Writing of his time in Auschwitz, Primo Levi, whom I'm sure you all know, spoke of his memory crowded with the faceless presences of emaciated men, on whose faces and in whose eyes not a trace of a thought was to be seen. As we reflect on the troubled claims to universality of human rights today, we need to move beyond an indifference to what sometimes becomes faceless presences. Deaths in the Mediterranean, the killing of children and widespread famine in Yemen, the brutal separation of migrant families here in Ireland and elsewhere, and everyday homelessness here in Galway persist despite the noble aspirations and language of the Universal Declaration of Human Rights. This evening, we're also marking the launch of two new programs, our Masters in International Refugee and Migration Law and Policy, and a Bachelor of Law in Human Rights, both firsts in Irish legal education. And we hope that through these initiatives, the School of Law and the Irish Centre for Human Rights will continue to contribute to educating new generations of human rights lawyers and advocates. Our chair for this evening is Judge Tony O'Connor of the High Court. I would particularly like to thank Judge O'Connor for proposing this event, for his commitment to encouraging lawyers and law students to engage with the law, to move beyond what Hannah Arendt referred to as a preoccupation with law and politics as being about ruling and the ruled, and to consider instead the possibilities of a vie active, an active life, a commitment to the ideal of the rule of law as essentially intertwined with human rights, activism and advocacy. Thank you very much, and I'm going to hand you over now to Judge O'Connor.
It's a great privilege for me to be here and to chair with so many distinguished speakers. Privileges bring obligations, and my obligation is not to waste your time, and I'm not going to waste your time. You have various biographies given to you in the acceptance for this lecture, and I'm not going to repeat them. I'm sure that you recognise the abilities of all of our speakers. I'm going to introduce you and just show you the format first. Dr. Robinson is going to speak for 20 minutes, and each of the other speakers are going to speak for 5 to 10 minutes, and then we'll have a panel discussion with questions posed by yourselves in relation to it. Siobhán mentioned that I had something to do with this. All of the organisation has to be attributed to NUIG, who I commend very much for organising this event. One thought that before you start listening to these distinguished speakers is just think about somebody who you might regard as a great advocate. Part of my interest in this particular event came from my cycling around Strade and going into the Michael Davitt Museum. And Michael Davitt was a remarkable person. But just think about somebody in your life, in your history, that you can identify and see what you learn from tonight as to whether you can be an advocate. Not everybody wants to be an advocate, but there are roles of being an advocate not only by words, but also by deed. Without further ado, I'll hand over to Dr. Robinson. Thank you.
Thank you very much for a very warm welcome. It's great to be back here in NUI Galway and to have the opportunity to take part in this very interesting evening on the necessity of advocacy. I was aware at quite a young age of the necessity to be able to advocate, to be able to speak with some wisdom or some eloquence or even some enthusiasm about things, but I had a problem. I had a big problem when I was at secondary school in Dublin, and that was that when I got up to speak, I was very shy, and I would blank. I would just lose it completely. So I tried to do debating in school, and then when I went to university, to Trinity, I decided to take part actively in debates, just to get myself, force myself to be able to continue to speak and follow the thread and not go blank. That was my big wish at the beginning, and I'm serious about this. I really remember how terrible it was to go completely blank in front of an audience and not know what was it I wanted to say, and just the shyness coming out. So I took part in quite a lot of debates, not just in Trinity, but also I was studying in the King's Inns to become a barrister, and there were good competitive debates in the King's Inns. My companion in those debates was Harry Wheelahan, and we won at least one of those debates, I remember. We celebrated a big win for the King's Inns. And then I was elected auditor of the Law Society, and I think my first real advocacy was the speech that I made in 1967 as auditor of the Law Society in Trinity. I decided to speak on law and morality in Ireland. That was to be the title of the speech. And I remember consulting and getting good speakers to come, but I also went to University College Dublin at the time to speak to Professor John F. Kelly. I'm sure many of you are studying Kelly's Constitution. And I had an interesting meeting with him because he said, I wouldn't really do that, Mary. There's no law in that. And I kind of felt, I think there is some law in this, And so I was a bit shaken coming out of the room, but I decided, well, I think I'm going to do this. And actually, I was very lucky because I was able to get HLA Hart over from Oxford. Kingsman Moore took part. And I'm trying to think, and I couldn't think on the way here this evening. There was quite a conservative Catholic lawyer also, but for some reason I can't remember his name. But anyway, he also took part. And what I was saying in that speech as auditor was that we needed to open up Irish society, and we needed to remove the ban on divorce in the Constitution. We needed to legalise family planning. We needed to remove the criminality of suicide. We needed to also remove the criminality of consenting male adults in private. I'd been reading the Wolfenden report, which was much discussed at that time, and it was these were issues that I felt quite strongly about. And after I graduated from Trinity, I was lucky enough to go to the Harvard Law School straight away, and I'm the class of 1968. So yes, I'm old. I'm the class of 1968. But that year, 1967 to 68, was an extraordinary year to be in the Harvard Law School, because many of my American contemporaries were very critical of what they called an immoral war, the war in Vietnam. And they were seeking to avoid the draft, which was a big problem for many of them. And quite a number of them were very interested in the civil rights movement in the south of the country, in poverty programs for particularly southern states. And that was what they were going to do when they graduated. And more than anything else, I saw a different world for young people, frankly, than the world I had left in Ireland. In Ireland at that time, you waited your turn and you got into your 30s, and then you waited and you got into your 40s. And maybe in your mid-40s, yes, then you could do things, you could take part. But these young people were taking their decisions, they were taking responsibility. And that had a big effect on me. I have to say that afterwards, when I came back to Ireland, I started studying law and practicing law. And we had an election in 1969, and I found out that the university seats in the election, the 3 seats for Trinity and the 3 seats for the National University of Ireland, were by and large filled by elderly male professors. So I questioned this, and the point was made, well, if you really want to stand, why don't you go forward and we'll support you. My husband-to-be the following year in 1970, sitting here in the front row, Nick, called it my Harvard humility that had me standing at that time for the Senate. But somehow it worked, and I got elected at that time. And of course, that opened up an advocacy. And the first issue that I tackled was part of what I talked about as the auditor of the Law Society, to change the law in relation to family planning and to amend the Criminal Law Amendment Act of 1935. It was quite a simple bill. I had 2 colleagues supporting it, John Horgan and Trevor West. And I completely underestimated the reaction, the hate mail, the being denounced in newspapers, being denounced from pulpits, and the Archbishop of Dublin, Archbishop McQuaid, requiring a letter to be read out in every diocese in Dublin that this measure, the bill that we were putting forward, would be and would remain a curse upon the country. It was heavy stuff. And I actually remember being quite affected by it, and Nick decided that, this was after we were married, the bill was submitted in early 1971. He burned a lot of those letters, and we both, I think, regret it now, because we're archivists, we like to have the material, and that material was just destroyed. So I had opportunities as a lawyer, as a teacher, as a senator to practice my advocacy. And at this stage, I could hold my speech. I wasn't nervous speaking. I could, I had. In fact, the teaching helped the advocacy as well, because when you're teaching for the best part of an hour, then you learn to keep going and you don't go blank. And then my life changed when I was elected president in December 1990. And I remember realizing that the inaugural speech that I made was going to be literally how I was going to try and be the president that I had tried to campaign to be. And therefore, I spent quite a lot of time with help from friends, particularly from Nick with his red pencil, to express what I wanted to do. And I just want to quote one thing that I said in my inauguration. I said that I said, looking outwards from Ireland, I would like, on your behalf, to contribute to the international protection and promotion of human rights. And the truth is, I hadn't the fuckiest idea how or what or in what way, if ever, it would be possible to do this. But I said it anyway, you know. and, and then things happened. I was asked in 1992 by the aid workers who were desperate about the famine in Somalia and the fact that there was fighting among the warlords, and would I possibly go to Somalia? And I knew that I couldn't go, obviously, as president without the permission of the government. And we kind of contrived things, I have to admit. We arranged that there would be a meeting of those involved in concern and goal and Trócaire, etc., who were working in Somalia, to come to Áras an Uachtaráin, and that RTE would be there, and that I would be asked on live television, would you come to? And I would say yes on live television, as long as the government will let me. And the government did let me, and that was a very harrowing experience. Really harrowing to see lines of women and men with small children and not so small children in their arms, literally starving. In fact, some children died in the arms of their parents before they could get to the feeding station. And I remember speaking as president from Nairobi at the end of the visit. And I'd been fine during the visit. We'd been there for about 4 or 5 days. I'd seen everything, gone to everywhere, and gone into a live theatre where legs and arms were being amputated off people who had been shot or in the conflict. And I was fine. But when I wanted to speak to the press, I actually found that my voice started to waver. I was clearly emotional, and I was furious at myself, absolutely furious, because I was the lawyer. I was supposed to be able to be detached, and here I was with my voice breaking, talking about the world needs to understand and the world needs to do more, etc. And I went up to my room afterwards, and Nick came up with me, and I think we both felt, you didn't do that very well. And then I actually saw it played on the television in the room that I was in. And I could see that it had huge impact because I had shown my emotion. And it was really very interesting. It was, a lesson that I learned that, I don't like when people, sort of sob to the sake of, getting sympathy and support or whatever. No, but this was an example. There's another example which I'm not so fond of addressing both houses of the Oireachtas. I did that twice. It's something a president can do. And the second time, I did it to talk about the Irish who had gone abroad over centuries and over recent times that we really didn't care enough about. And as a senator, I had spent some time with the Irish immigrant centres in the UK, in Canada, in the United States, and even in Australia. I'd been to Australia as a senator. And, I was very proud of these centres, particularly because they also reached out to non-Irish. They were very inclusive and they were very good with their values, etc. And I wanted to talk about the Irish diaspora. Having been president for several years, I was very aware that we were one family and that this was the wider Irish family. And I wanted to use a word which wasn't very common in those days, the Irish diaspora. I got some negative reaction to that initially, and I actually asked my father. I said, well, what do you think about, calling the title the Irish diaspora? He said, yes, go ahead. The Irish love new words. They'll like it. And it did become, but I made my speech in the, to the two houses of the Oireachtas. And I was so kind of caught up with how much I wanted to make that speech and really make a really good speech, etc., that it was terribly preachy. And I sometimes watched it, and I say to myself, I would never do that now. I would never give a speech like that. It actually was very badly received. The members of the Oireachtas did not like being preached to by the president, I'm telling you, not one bit. And there was no humour, there was no self-deprecation, I was so on message with my message. I think, luckily, my message got out around the world. Ted Kennedy put it on the Library of Congress. I got letters. There were no emails in those days, practically. I got letters from various people around the world. The one that affected me most, I think, was a nun, an Irish nun in China. And she said, I have heard your message. I don't think there's an Irish person within 1,000 miles of me, but I'm so happy, etc., etc. It was a lovely letter. And so the immediate audience felt preached at, but a wider audience got the message, and I was sort of pleased about that. I then became High Commissioner for Human Rights of the United Nations, giving leadership on human rights, gender, rights of people with disabilities, rights of indigenous peoples, and I had no big stick. So advocacy was so vital, and the advocacy was very often going to the worst places of human rights abuses and listening, and the power of listening I learned, just not having any possibility of changing people's lives, but giving them that sense of respect that they were being listened to, and then coming back and helping to get their voice out. That was the important thing, that as High Commissioner, I had the opportunity to speak directly of what I'd seen, what I'd heard, and to hold governments to account, to ask the UN to do far more, etc. And, after the United Nations, well, first of all, I've often admitted, because I'm now very focused on climate justice, that in my time as High Commissioner, those 5 years, I didn't make a single speech on climate, because I was in a way in a silo. It was a big silo, human rights, gender, rights of people with disabilities, indigenous, etc. But there was another part of the UN dealing with climate change, and I didn't make the connection. It was when I was working in Africa on economic and social rights, rights to food and health, and women, peace and security issues and corporate responsibility, that everywhere I went, I heard the same sentence, more or less, that things are so much worse. And it was because everything had become so unpredictable, so impossible. We don't know when to sow. We don't know when to harvest. It affected food security. It affected very poor livelihoods. Women had to go further for water, had to go further for firewood, and so on. And I gradually understood the link that climate change is undermining human rights, that it's a key issue of human rights. It's probably the biggest issue of human rights of this century now, because we're facing an existential threat, as we know from that recent report of the Intergovernmental Panel on Climate Change. And I founded my foundation here in Ireland, in Dublin, the Mary Robinson Foundation Climate Justice. And then, believe it or not, I learned that I couldn't do advocacy for my foundation on human rights and gender, because a charity cannot do advocacy on human rights and gender under Irish law. Think about that. Strange, but it's true. So I don't do advocacy. I do persuasion. I do... I promote understanding. I sometimes get very bossy, but whatever it takes. But that is an interesting thing about charities. But I do want to end with a kind of sense, since this is the School of Law and the Centre for Human Rights, the Irish Centre for Human Rights, that I've always been very admiring of, and I'm delighted that you have a great director of the centre again. But I believe now that law schools and centres for human rights have to centre the agenda for our world as part of their advocacy going forward. And the agenda for our world is the 2030 Agenda with its 17 Sustainable Development Goals and the Paris Climate Agreement. Agreed, negotiated in the case of the 2030 Agenda by 193 countries, and they agreed it. In the case of the Paris Climate Agreement, 195 countries, and they agreed it in 2015. It's still the agenda for the world. We're in a bumpy time, we've populism, we've President Trump, we've all that, but the truth is, that is the agenda for our world. And we now know far more about what the goal of the Paris Climate Agreement really means. The goal is that we stay well below 2 degrees of warming above pre-industrial standards, meaning middle of the 19th century when major manufacturing, etc. started. So we stay below 2 degrees of warming above that, and we try to stay at work for 1.5 degrees. And it was the small island states, it was the least developed countries that argued for the 1.5. I heard that mantra over and over again coming up to Paris. 1.5 to stay alive, 1.5 to stay alive, because these small islands knew they would go under if they didn't get the 1.5. I thought when we got it, and I was very pleased we got it into the text, that this was for the small islands and the poorest countries that were most disrupted and buffeted by climate change. Now this report, the other day, of the scientists around the world, the Intergovernmental Panel on Climate Change, have told us, no, this is the standard for all of us. We have to stay at 1.5 degrees and not go above it, or if we go above it, somehow come down again and stay at it as being the only safe world. And the difference between 1.5 and 2 degrees is really, really serious. It's the time between 1.5 and 2 degrees when we lose the coral reefs, when we lose the ice of the Arctic, when we get the permafrost starts to melt, and then we get into the loopbacks, or whatever they call them, where Mother Earth, the Earth, which is very good to us at the moment in absorbing so much carbon, it absorbs it in the water, in the oceans, it absorbs it in forests, but it could turn around and not absorb and change very dramatically and get us into a worse and worse situation. So at the moment, we're on course for a 3-degree world. The scientists have told us we need to reduce our emissions by 45% over the next 12 years. Actually, it's less than 12 years, because it's 2030. Reduce by 45% and then go to zero carbon, zero fossil fuels by 2050. And this has huge implications for every discipline, but it has massive implications for human rights, for gender, for just transition, for law schools around the world, lawyers around the world. All of you, in your future, this should be something that you take extremely seriously. And that's the end of my advocacy. Thank you very much.
Thank you very much, Dr. Robinson. I just felt the personal and the human touch, but intertwined in all of that, there are strands of what advocacy is about, not just the persuasion. Judge Dennis MacDonald mentioned to me he was lectured by Dr. Robinson, and he said to me, she was in so many cases. She's so modest that she didn't touch upon her legal career. I thought I knew of some of the cases that she was in, and sometime when you have time on your hands, go into Justice or one of the and put in Mary Robinson in inverted commas into the search, and you will find out the cases that she was in. And what struck me was how she can remain dispassionate. She's passionate about climate change now, but how she dealt with cases. And so many of the cases, I don't think I've ever come across somebody who has been defeated in the High Court and gone to the Supreme Court and got the Supreme Court persuaded to change the law. Just one or two examples of it. O'Brien and Borden-Namona, close to my heart, all about bogs. Fair procedures when you're compulsorily acquiring it. EK and the Nursing Board, where the nurses who were disciplined had a right of appeal to the High Court. Most significantly, and this allows me to introduce our next speaker, Webb in Ireland, 1988, won Irish reports, all about finding treasure and who is entitled to be paid for it. And she was led there by Gerry Liston, who I'm going to, his grandfather, and in that particular case. But that dealt with so many issues. De Burke and the Attorney General, the composition of juries and the selection of bias based on property qualification. That's only a taste of it. But she's glided over in the limited time. But what I think that you will take from it is the speed with which she's gone through life and touched so many people with her abilities. I said I wasn't going to waste your time, and I don't mean to be wasting your time by giving this eulogy to Dr. Robinson. But without further ado, I'll ask the representatives from GLAN, the Global Legal Action Network. I'll leave it to them to decide who goes first, Dr. Gearóid or Quinn or Gerry Liston. Very good.
Thank you very much, and it's an honour to be here and to share the stage with Dr. Robinson. And I'd first off like to advocate that that is a hard act to follow. I am director of the Global Legal Action Network. We've recently partnered with the Irish Centre for Human Rights, and we've established a placement scheme, and I see some of the students who are now working with our organisation. And I'd like to talk today about the role of legal advocacy and advocacy in general on transnational and international issues and the importance of it. Most notably, how we contend with scale, with values. There was a reference to populism earlier on, and also about the life of the law. And I'll touch on each of those very briefly. I won't, again, waste your time, but try and bring it on to questions and answers as soon as we can. First off, our organisation, our mandate is the taking of legal actions across borders that challenge the behaviour of powerful actors involved with human rights abuses. So this means we try and figure out clever ways to use the law here to have an effect overseas where human rights issues are more prevalent or severe, where access to justice is restricted. And in a globalised world, we are connected in all strange and beautiful ways, and we're trying to use the law in strange and beautiful ways to try and improve how we are connected to the world beyond our borders. So the themes we touch on include such pressing issues as migration, such pressing issues as climate change. Indeed, we were inspired by the articulation of Dr. Robinson when we first started this off, of climate change as a human rights issue and something that lawyers should be tackling actively and litigating on. We're also interested in the issues of forced labor and slavery. And we're bringing sort of interesting cases. We recently brought a case against Italy for its role in coordinating the Libyan Coast Guard to intercept migrants who were then subsequently sold on into slavery or abused and then subsequently deported. And we brought, using a specific incident, a case to the European Court of Human Rights against Italy on this. And this was a challenge for a number of reasons. There are certain psychological hurdles that happen when scale enters the equation. The bigger the numbers, the less sympathy. As Stalin said, if you kill one person, it's murder. If you kill a million, it's a statistic. It's what's known as the collapse of compassion. So in this work, when we're dealing with these large issues, I think advocates should be aware of this. And I think they should be aware of the research that psychology shows that there are ways around this. There are ways of properly dealing with scale so that we resonate with people, and that we should consciously think about how we advocate, the language we use, how we frame things. Public health research has shown that how you frame things massively influences how we debate and policy those issues. We can think of a very immediate example on this. The unfortunate situation of Mr. Khashoggi, who met his grim end in the Saudi consulate in Istanbul. That has attracted worldwide attention. The plight of him and his family, who were recently paraded on Saudi TV, has captured the imagination. Well, at the same time, the 10 million people on the brink of starvation in Yemen, as a result of the Saudi-led airstrikes, are not capturing the same public sympathy. Again, scale is a problem. And advocates, I think, need to use the law, but articulate it through visceral examples, through ways that resonate with the target audience they're seeking to achieve that tipping point with, as has happened in the cases of sexual abuse inquiries, where that tipping point occurs and we see change. Because ultimately, we do want to use the law as an instrument for social change. The other thing I would like to point out is that values. It seems in the Trump era that we are more polarized than ever. And again, here I think framing is extremely important. When we were litigating and conducting this case on the Italian migration and looking at the Libyan Coast Guard, it was incredible to see how the headlines were spun. Rather than us saying, look, you can govern migration, but maybe don't abuse people. That got spun into vexatious migrants sue Italy. We almost lost control of the narrative. It was almost a case that we risked doing more harm than good. So when dealing with these problems, I think we do have to be mindful of creating new risks as well. It isn't just plain sailing. We use a bit of psychology and we achieve change. We have to be mindful of the risks that we bring. But nonetheless, I think litigation does provide us with an opportunity to overcome many of these psychological hurdles, and a chance to deploy narratives that are effective. I think that's because litigation has a very particular structure. It's structured in a way to trace harms, to trace injury, to specify what the harm is, to take it away from something that's uncertain and abstract, and then to trace that harm back to a defendant. It makes it, for us, real. And I think that's why litigation is sometimes so attractive for people who are seeking social change. The last thing I'd like to share from our experiences in dealing with these types of issues is that it's good to take these types of actions, but what I discovered early on is after you take it, sometimes you may even choose to secure a legal win without achieving victory, where you lose in a court case, but at least you've raised the profile, you've provided a platform. In those situations, the case may die. The social media graphs die off, the tweets stop, Facebook shares go down, the newspapers move on to the next thing. It's a very dynamic space. I think that in addition to bringing these types of legal actions and achieving publicity, we have a responsibility to move it forward with good advocacy. And that can only be achieved by linking with people who are outside of the law, in social movements who are effective, who know the issues, who are connected to communities, who can bring life to these actions beyond the mere headline or that spark of publicity. And that's it. That's really my contribution, I think, from our work at the Global Legal Action Network, working on these issues. And my colleague Gerry Liston will say more about some of our work on climate change litigation that will give you a greater insight into our thinking on these matters. But thank you very much.
Well, equally, thanks very much for the opportunity to speak here. It's a real and slightly daunting honour. But I thought I'd just share some thoughts with you on the necessity of advocacy from the point of view of some of the work that I've been involved in with the Global Legal Action Network. As Gearóid mentioned, the advocacy work that we do is primarily legal in nature. And I suppose in terms of the necessity of that work, it's worth thinking about how a case in the ordinary way starts, just an ordinary everyday case. So imagine someone who is injured through the wrongdoing of another person. That person is likely to appreciate at least the possibility that they might have some sort of legal claim against the person who's caused them the wrongdoing. And in Ireland, the injured person, will then go to a solicitor, and that initial element of knowledge that the person who's been harmed has is what actually sets in motion the legal case. But imagine you're a farmer in Uzbekistan, a cotton farmer in Uzbekistan. And in Uzbekistan, the government operates a very brutal forced labor regime where it forces farmers to grow cotton every year and to meet extremely onerous quotas, which it enforces through extremely punitive measures, including sometimes physically beating the farmers. The European Union is not only does it permit the importation of goods that are produced, the cotton goods that are produced, or at least the cotton itself that's produced by these farmers into the EU, it's actually actively encouraging the trade in this cotton. And as a farmer in Uzbekistan, you're highly unlikely to appreciate the possibility that there might be some basis on which to challenge these measures that are going against what every expert on forced labour will tell you should be done in order to eliminate forced labour. And that's actually a challenge that we're hoping to commence very soon. And I think as a case, it illustrates the necessity of lawyer-led legal advocacy on behalf of those who are subjected to human rights abuses, particularly where there's a transnational dimension involved in sustaining those abuses. Another question then is, where does political advocacy in the political arena, how does that relate to the advocacy in the legal arena that we're involved in? And Gearóid mentioned the climate change litigation that we're involved in. It's a somewhat ambitious case where we're hoping to bring up to 47 countries to the European Court of Human Rights, hopefully commencing it in the early part or mid part of next year, essentially relating to the failure by these countries to properly address climate change. And we were discussing prior to the talk this evening the Mothers of Invention podcast that Dr. Robinson and Maeve Higgins, I think is the comedian's name, who are producing it. And the first episode of that podcast, which I'd highly recommend people to listen to, and was of particular interest to me, is on climate change litigation. And one of the people that was interviewed on that particular podcast was someone called Tessa Khan. She's a lawyer with the Urgenda Foundation, and people might be familiar with Urgenda. They achieved a major victory in the Dutch District Court in 2015, securing an order from the court against the Dutch government that it must take significantly greater action in cutting its greenhouse gas emissions. And what Tessa said, or one of the things that Tessa said on that podcast, was that cause-driven litigation is only as strong as the social movement behind it. And I think that's something that we've become very conscious of in our work with on these particular issues, and not least in relation to climate change. And I think it reflects the fact that while courts, of course, respond to the legal arguments that are put before them, there's also evidence to indicate that, at least in relation to high-profile issues and causes like climate change, that they're also responsive to the work of activists that take place outside the courtroom. And I hope I'm allowed to say that in front of the members of the judiciary who are here this evening. And then, of course, there's a converse to that, in that litigation can help to fuel and support and galvanize support around the issues outside of the courtroom that are being addressed in the courtroom, because legal cases obviously help to draw a huge amount of attention to a particular issue, and that's something that we're very conscious of doing effectively along the lines that Gearóid mentioned with the various cases that we're involved in. So that's just a very brief reflection on the necessity of advocacy from the perspective of my work. Thanks.
Gearóid and Gerry, thank you very much. You're only getting a brief snapshot of what they do, and I think it's, again, feeding into what advocacy. There are so many strands to it. It's hard to just grasp, but hopefully we'll excite some interest in the subjects, but not the material subject, but how advocacy can work. Gerry just mentioned about cause-driven litigation and with paying due respect to the courts. I'm first to acknowledge that we are the weakest link in the power of government, and that's not taken away from it what we do. But I would say that the power of persuasion through politics, media, discourse in universities is so important. Again, I'm not going to waste your time with further ado. I'm going to ask Dr. Maeve O'Rourke, who will be well known to you, to speak to you for a few minutes.
Thank you so much, and thank you for having me here this evening. When I was in law school, I thought that human rights law was mostly about litigation. I thought that's what lawyers do, that's how they bring about change. That's how Mary Robinson brought about change. So soon after leaving UCD and finishing my master's, I sat the New York bar exam, and I was called to the English bar, and I then practiced for a few years in family law, and also on a major environmental case against Shell Nigeria. I've since realised, though, as a result of the voluntary work that I've done for the last 9 years while working full-time as a lawyer and then writing my PhD, that lawyers are badly needed for legal advocacy and legal solutions outside of court too. And that is what I'm going to focus on in the next few minutes. I should mention before I describe some of the work that I've done that I've always loved research, and next year I will be joining NUIG as a lecturer. And I think there is a huge need for human rights advocacy by academics too. Academics who've had the chance and taken the time to research a problem and to consider and compare possible solutions to that problem. The world needs to know of the analysis that academics carry out and the solutions that they propose. And I do think that the people whose lives they're studying deserve that. So I believe that whether human rights advocacy is done in court or in politics or as an academic or as part of a social movement or in one's professional or personal life or as a combination of all of those, it's really important to work in a deeply collaborative way with the people who are affected by the human rights violations. And so going back to what I originally thought human rights lawyering was all about, that is professional legal practice, what I want to focus on is that I actually think that the methods of legal professional practice have a lot to offer in terms of how we collaborate on human rights cases and issues outside of court. A practicing lawyer always makes their case on instructions from their client. That is the golden rule. A lawyer is essentially their client's mouthpiece, although of course they offer advice and information to their client before taking their client's final instructions. A lawyer forensically gathers the information relating to their client's case. They look for all of the available evidence and they put it together carefully. It usually includes witness evidence, any documentary evidence, and all other forms of direct and circumstantial evidence that can be found. The lawyer then presents the full detail of their client's case before a decision maker, and the lawyer makes carefully considered factual and legal arguments, having thought about and tested the other side's likely responses. So I'd like to share some examples of my own legal human rights advocacy as a way of demonstrating this, what I believe to be an effective way of lawyers engaging collaboratively with people from other disciplines, but doing what they can do best to advance human rights causes. The first example is the Justice for Magdalenes campaign, which helped to bring about the Taoiseach's state apology to survivors of the Magdalene laundries in February 2013. I was also lucky enough to go to Harvard Law School straight after my undergraduate law degree in UCD. And this work that I did with Justice for Magdalenes all came about as part of my master's research. I had the exact same impression when I went to Harvard. I saw a different world to the one I was used to in Ireland, albeit I think 4 decades later. Young people really were all about taking responsibility. And in class, it wasn't like people were just going to be applying the law, they were going to be making the law. So I had gone to Harvard in 2009 just as the Ryan Report, which looked at endemic abuse in state-funded church-run schools in Ireland, had come out. And I remember just being absolutely shocked and shook, thinking, I don't need to go anywhere to work on human rights. And immediately upon getting to Harvard, I started to study sex equality with Professor Catherine McKinnon, one of the world's most famous radical feminist lawyers. And a paper that I wrote for her was a gender analysis of how Ireland had dealt with its legacy of church-related abuse. And I ended up in office hours with her, and I ended up talking about the Magdalene laundries. And she just looked at me and said, what are you going to do about it? So for my LLM thesis, I started to look into state responsibility for what had happened in the Magdalene laundries. I met a professor, Jim Smith, who was in Boston College, who was working with a very small group of advocates called Justice for Magdalenes, a completely voluntary group. It was Jim Smith, an academic, Dr. Catherine O'Donnell in UCD, another academic, Claire McGettrick, who's an adoption rights activist, and Mary Steed, whose mum was in a Magdalene laundry for many decades. Jim Smith, by the time I met him, had gathered a large amount of evidence from state archives demonstrating official involvement with the Magdalene laundries, in the sense that the courts had sent some girls there as an alternative to prison, and also that laundry had been washed, state laundry, a lot of state laundry had been washed by the Magdalene laundries. And Justice for Magdalenes, by the time I met them, had presented draft language for an apology and a redress scheme to the government, because they'd kind of taken the opportunity when there was all the attention on the Ryan report in 2009 to suggest that something similar should be done for women who'd spent time locked up in Magdalene laundries. But the answer they kept getting was no. The Magdalene laundries are different to the industrial schools. They were private institutions and the state did not regulate or inspect them. The officials were refusing to countenance apologising or providing redress. So when I met Professor Jim Smith as a master's student, I realised that what was needed at that point was a legal analysis of what had actually happened to the girls and women in the Magdalene laundries, so that legal arguments could be made about why the very fact that those institutions were not regulated or inspected was a violation of state obligations, not an excuse. I spent months writing my LLM thesis. I recovered RTE radio tapes and I found previous TV documentaries, and I transcribed what the women had said in those documentaries about what had happened to them. And I argued ultimately that the abuse had amounted to forced labour or servitude or even slavery, which Ireland had been obliged to prevent and suppress, and certainly not to be involved in on a commercial basis since the 1930s. These legal arguments then contributed to Justice for Magdalenes' application to the Irish Human Rights Commission in 2010 for an assessment of the state's responsibility for human rights violations. And the Irish Human Rights Commission did quite quickly recommend a statutory investigation and compensation where appropriate. Then I was in London on a fellowship from Harvard, and I started in my spare time to take witness statements from women who had spent time in Magdalene laundries. These women were part of state-funded groups for survivors of industrial schools, and as we now know, there was lots of crossover, lots of direct transfers from industrial schools to Magdalene laundries. So I took witness statements, and I brought these statements and further legal arguments before the UN Committee Against Torture in 2011. The UN Committee Against Torture echoed the Irish Human Rights Commission's call for an immediate independent investigation and for accountability and redress. And those actions then prompted the setting up of the Magdalenes Committee that inquired into state interaction with the Magdalene laundries. But the legal work outside of court was not over. We were worried because the government didn't give the Magdalenes Committee the remit or the powers or the mandate to investigate abuse in the Magdalene laundries, simply the question of state involvement. And also, apart from Senator McAleese being independent, all of the committee members were senior civil servants from the very government departments that ended up being found to be completely involved with the Magdalene laundries. So in order to hold the process accountable, I worked with a barrister in London and the members of Justice for Magdalenes to gather about 800 pages of witness testimony and over 3,000 pages of archival evidence, which we summarised in a 150-page legal submission, essentially a skeleton argument, which essentially said, we have enough here for a High Court case, or many, if the right thing isn't done by the government. We were able to share this submission in redacted form with all TDs and senators in 2013 when the report of the Interdepartmental Committee was released. And I do believe that this contributed hugely to bringing about the state apology and the redress scheme after that. The testimonies that we gathered and the submissions and the archival evidence are also an important contribution to the national historical record. And I think that they'll be really important in what I see to be a movement towards national commemoration and education, increasingly. So having learned from that whole process, I set up a similar initiative in 2015 after the government established the Statutory Commission of Investigation into mother and baby homes following on from the Tuam revelations. The CLAN project is a collaboration between Adoption Rights Alliance and Justice for Magdalenes Research, both voluntary groups again, and the global law firm Hogan Lovells. Over the past 2 years, 69 lawyers in the London and New York offices of Hogan Lovells have given free assistance to anyone who wanted to make a witness statement to give to the Commission of Investigation into Mother and Baby Homes. And shortly we'll ask witnesses if they would like to deposit their witness statements anonymised into a public archive for future generations. We published the first major report of the CLAN project last Monday, which is a 150-page compilation of factual evidence and legal argument, and based on 77 witness statements, and there are more in the process. It contains human rights legal analysis and recommendations for how to achieve human rights-based reparation for the past treatment of unmarried mothers and their children. And last Monday, we focused on the ongoing human rights violations that are occurring because of denial of access to personal files, and also the secrecy ongoing of administrative records, which are still held by a variety of private church and state entities. And the fact that the Clan Project witnesses, even at the launch last Monday, own a copy of their witness statement, own their testimony, and were able to speak from it, demonstrated starkly the difference between that approach and the fact that anyone who's given oral evidence in private before the Commission of Investigation isn't actually entitled, because of the legislation underpinning that investigation, to a transcript of what they said, because the legislation intends for the Commission to create an entirely sealed archive. So on that note, I just want to sincerely thank the organisers for inviting me to be here. I've always been inspired by Dr. Robinson's work, so it's great to be able to say that in person and to thank you.
Thank you very much, Dr. O'Rourke, for that. I won't elaborate any further, other than to say that it's amazing about all these speakers. They don't talk about their own personal sacrifice, that they're so committed. But the point that she was making about the role of lecturers and academics, I think, feeds into the next speaker, Professor Niamh Reilly, who will be known to many of you here. And again, I would refer you to the biography. And I hand over to Professor Reilly.
Thank you very much. I'm really delighted to be here. I think as the one non-lawyer on the panel, which is great. And just to say, I hope there's a lot of art students in the room. They're the best advocates. Just a few comments really. I mean, the very difficult times that we're in at the moment has been alluded to, but really in the last decade and a half. As I speak really as a political scientist and thinking about the conditions for advocacy and the threats that the human rights paradigm itself is facing. The war on terror of the last decade and a half plus has really eroded efforts to deepen and extend what is always a very fragile consensus internationally around our shared human rights values. The return of strongman politics, autocratic politics, where there's almost a bravado about overtly dismissing the relevance of human rights. Globalization that has brought a lot of positive things, but brought social fragmentation. The digital media revolution, which has fragmented our public spheres. All of these frustrate our efforts to organise collectively and act in concert on human rights issues. The rise of populist nationalisms and xenophobia, and also the compelling critiques from people on the left and liberal intellectuals of those moments when human rights gets it wrong and when human rights is often invoked while human rights abuses are being committed. And this also undermines human rights. So it is, these are very difficult times, and we do need to, those of us who are committed to human rights, need to take extra effort to ensure that the human rights framework and that the commitment to human rights is reasserted and reaffirmed and bolstered. The one thing that I want to focus on is really in praise of long-haul advocacy. I think sometimes, we're sort of limited by our egos as human beings, and we kind of hope that if we put in a couple of years here and a couple of years there, we're going to change the world. But, we will change the world, but we'll change the world through our contribution to the long haul and incrementally. I thought it would be appropriate. I'm doing some work at the moment on the political and social thought of Tom Kettle. And for those of you who aren't familiar with Tom Kettle is a great underrated essayist, writer, poet, one of the last of the young parliamentary nationalists, a very reluctant barrister who died in World War I. But he had this to say about the advocacy journey, about the moment of kind of recognition of a wrong, and about changing it through the law. And he was speaking in 1905 giving an inaugural lecture to the Young Ireland branch of the United Irish League. He says, "You would do well to study the trials through which an idea passes before it becomes a law. It arises out of the misery and contains the salvation of a people. The state welcomes it with a policeman's baton. It recovers. The state puts it in jail, on a plank bed, and feeds it on gruel. It becomes articulate in Parliament. A statesman, from the moral altitude of £5,000 a year, denounces it as a devilish device of a hired demagogue. The idea, it grows old, almost obsolete, no longer adequate. A statesman steals it, embodies it in an act, and goes down in history as a daring reformer." It is this idea that the process of change is fraught and tortuous in terms of this interface between politics and the law. And achieving change takes time, tenacity, and endurance. And the deeper the injustice to be tackled, the longer it takes to begin to set things right. And it is multi-layered. It is a multi-layered project, as has been said. It has legal dimensions, political dimensions, but also cultural, social, economic, and successful advocacy needs, as has been acknowledged, a multidisciplinary approach. It needs strategies across the board to tackle it. And in terms of this cultural dimension of advocacy, the post-colonial feminist critic Gerry Spivak often talks about how achieving change requires the uncoercive rearrangement of desires on a person-by-person level. It is a slow, painful process, in common parlance, changing hearts and minds. And I think, when Mary Robinson was out there advocating in the early 70s for a liberalisation of contraceptive law, advocating for the decriminalisation of homosexuality, advocating against the proposed Eighth Amendment to the Constitution, it would have been hard to imagine the transformation in hearts and minds, the rearrangement of desires in the hearts and minds of people in this country that has taken place to allow the changes that have taken place, but some 35 years later. So it's a long haul, and that advocacy begun then comes to fruition now, and then there are still new challenges to be tackled. My own work, over the years, I became deeply involved in human rights advocacy in the early 90s. I had the privilege to work with a very wide international network. I was based in the United States, part of the diaspora, and I don't think Mary Robinson really ever appreciates the huge impact that she had on those of us who had emigrated and were living away, and were hugely uplifted and energized by her recognition of us. Because Ireland, even in my coming of age in the 80s, was a very bleak place. It wasn't a place that you really wanted to stay in. You wanted to get away to new horizons, and it is now a transformed place compared to that. But I began working with the Global Campaign for Women's Human Rights, with a Rutgers-based Centre for Women's Global Leadership, which again was this academic situated advocacy organisation. And there wasn't a lawyer among us, but we soon forged alliances with lawyers most of whom were working in human rights organisations, big human rights organisations. And to give an indication of the transformation that occurred between then and now, the early 90s and now, in terms of women's human rights, the first task was to get Amnesty International on board, who was very conservative and very reluctant to acknowledge what it meant that women's rights are human rights, that it would overwhelm the human rights agenda, that women's rights are important, yes, but they're not human rights, and so on. So and now today, Amnesty International is one of the leading organisations in really pushing that agenda of women's rights are human rights. So the other thing that I just want to focus on, that I just want to underline, and I won't take much time, and it has been mentioned by a few people, and I'm glad it has, which is the role of the university, and I would say the role of the public university. In the last year or two, I think we've become more aware of the role of the media in keeping a spotlight on human rights abuses and in holding power to account, particularly in this context of autocratic and populist politics. And I think the university, the public university, has a very particular role to play. And I think in this recognition of the multidisciplinary nature of advocacy and long-haul advocacy, really ensuring that the arts and humanities, Gertrude Spivak in particular sees humanities education as absolutely pivotal in this reorganisation of desire in order to achieve the social change that we need. That we really need to make sure that in the current climate, and particularly with the influence of commercial and free market logic, which is affecting the university sector around the world, that education for civic engagement and advocacy is not squeezed out, that it is very much front and centre and invested in by public universities around the world. So I would just finish with another quote from Tom Kettle, if you don't mind, from the same essay, The Philosophy of Politics, when he asks, well, with what attitude should we approach our advocacy and our political engagement? And he says, cynicism, however excusable in literature, is in life the last treachery, the irredeemable defeat. We must be content, or try to be content with little, but we must continue to be loyal to the instinct that makes us hope much. We must believe in all utopias.
Thanks very much, Professor Reilly. The long-haul advocacy through education certainly sticks with me. And that brings me neatly to our last speaker, Professor Donncha O'Connell, who'll speak to you. I've been a long admirer of what he's actually done here in NUIG. Without further ado, I'll pass over to him.
It's a great honour to be here, and I'm very grateful for the invitation to speak to this gathering. When I was a student doing the LLB in the 1980s, I was from the class of 1968 as well at Castlebar Maternity Hospital, 1968, and I remember picking my subjects, my elective subjects for the LLB, and a friend of mine said, "What did you pick?" And I said, human rights 1 and 2 and public international law. And he said, yeah, you love the bullshit law subjects. And he's now a very successful barrister with an enormous farm. And I'm teaching people who want to be him. But there is though something about what we do, and I decided, when I was asked to speak this, is that I'm going to talk about reflective advocacy, and then I decided, well, I better reflect about what I'm doing. So I thought about it this afternoon, and one of the things that I thought about was we separate academic education from professional legal formation in this country, and people sometimes complain about that, say, no, you should be more integrated. There's advantages, there's disadvantages. But I actually think from a long experience of working within the system and having done professional formation as well, that I think there's a great advantage in having a separate academic phase in your life. There's scope for critical analysis, for theoretical exploration, and critically, I think there's scope for idealism. There is actually a moment in life when it's easier to be idealistic than it is later. And I think if we don't do something about that when we are students or when we're teaching students, that is a huge missed opportunity. I also think that when professional formation takes hold, if you go on to become a solicitor or a barrister, and I am somewhat focusing my comments on law students, students can be sometimes pressured to choose between their high-mindedness or between what is, or what is considered useful or valuable. And if the foundations aren't good from the academic period, that choice might be a bad choice. I still think it's possible to have both. So if you integrate fully professional formation and legal education, I think you would compromise the advantages of academic education. But I do think we need to punctuate the academic curriculum with exposure to reality checks and real life experience. And we do, I think, in the Academy now, by our commitment to clinical legal education, to mooting, to placements in organizations, we've normalized that in academic institutions, and I think that is very good. And subjects like human rights and subjects like international law are mainstream law subjects. They're no longer considered marginal or some kind of an indulgence. And it is, I think, critically important that we say to students when they are law students or doing law with another discipline, that this is their period of freedom from professional formation, that there is something different about that context than the context in which you are being professionally formed. And it's good that people go on to become barristers and solicitors. That's perfectly fine. It's even better if they go in without law as their primary background. And we have had for years here, I'm myself a graduate of the BA with law, we've had that for a long time. When I did law here, I did it through arts. My other subject was sociology and politics. And we had people like Michael D. Higgins teaching us, where there was certainly an emphasis on advocacy and indignation and all that goes with that. So when we look then at advocacy, and again, I actually teach a course with it in the title, but you can't really teach advocacy, I don't think. So you can have the advocate who's the lawyer, the disinterested lawyer, and teaching students about disinterest is, I think, a really, really good thing. It's a very, very key skill. But also you have self-advocacy, and we have within the school, through the Centre for Disability Law and Policy, a very interesting project, which tonight is in fact having a big launch in Dublin, the Irish Human Rights and Equality Commission, the Voices project, which is a project of self-advocates on legal capacity. So, what use then are we as lawyers? And I think this is a very, very important question. We can't just presume that we lead all these things or that we're valuable in some sense. We have to actually ask what use we have. And I think we're very useful if the change that is sought comes in the shape of law reform. But not all change that is sought comes in the shape of law reform. It can be legislative, or it can actually be a litigation outcome, which is, I think, something quite different. And it doesn't follow that lawyers are best placed to lead organizations that are focused on this kind of change, if it's social change or if it's political change. In fact, very often that's a bad idea. It's much better to have the lawyers doing what they're actually good at. And the change that may be sought may not be all about law. Law may be an element of it, but there may be other components to the change. And what then limits our usefulness as lawyers, and what can law schools do to address those limits? Because I think there are real limits in how lawyers are formed when it comes to advancing social change or ambitious change or radical ideas. And I think one of the things that we have to work on very, very hard in the law schools is that we need to inculcate, I think, skepticism in law students. There's no point in teaching somebody about the separation of powers as if that was some kind of self-evident truth or as if it was some self-sustaining mythology. You have to actually interrogate fundamentals like the separation of powers so that when students, law students, understand that concept, they do so not from a position of belief, but from a skeptical or a critical position. And I think if we, in our teaching, encourage people to buy too much into the mythology of systems, if we say that the law is neutral or devoid of ideology, or that judges simply apply the law almost in a robotic manner with no subjective input, I think we are doing a disservice to law students. I think this is particularly important in areas like constitutional law. And if it didn't matter, well, then why would they be advocates? What would the advocate be doing if they're simply appealing to a judge who will mechanistically and without subjective input dispense an outcome without some persuasion or something other than that? And that is, of course, the whole point of legal advocacy. So as legal educators, I think our duty is to appeal to the imagination of law students, encouraging creativity, but maybe not adventurousness, explaining risk, but not to the extent of inculcating excessive caution. And when Tony referenced all of the cases that Mary Robinson was involved in. And I found this myself for years and years of teaching. When you go through, if you teach a subject like constitutional law, it's almost like a litany of the risks taken by Mary Robinson as a lawyer. I think calculated risks some of the time. But to mention that in the teaching of those cases, particularly if you teach also stuff, things to do with the ECHR, again, critically important. If that hadn't happened, the role model wouldn't exist for future public interest lawyers. And then when we turn, say, to the international system, I think one of the ways we get bogged down in Ireland about this contest between domestic law and international law. It's a completely pointless debate. I think if we look at the international system now, you can borrow the tagline of T.G. Cahir. It's Sualella. It's another perspective that you bring to the teaching of law, if you see it merely as an educational tool. And I think we've always done this, to be fair, in Galway. I think you should have in legal education a conscious cosmopolitanism. It shouldn't just ever be about one system. That's actually a very dangerous thing. There should be a conscious cosmopolitanism in the way in which we teach either international law or comparative law. And we should avoid particularism. And this is perfectly consistent with legal education in a common law world. We don't use the phrase the common law world for no reason. It's about more than one country's legal system. It's about, in fact, many countries' legal systems, but not all the legal systems in the world. Just by way of footnote in relation to that before I finish, the other dimension, I suppose, of the international context would be EU law. And post-Brexit, this creates a really interesting challenge for a country like Ireland, because we will be the only remaining common law jurisdiction in the EU. But it may also signal the end of the common law for a jurisdiction like Ireland. It seems a little bit alarmist to suggest that, but it may be foreseeable that within 30 to 40 years, the common law may not be what it has been in a jurisdiction like Ireland. We may be much more a country of European law more directly applied. And that could be a good thing or a bad thing. There's a technocratic, arid, inaccessible side to that isn't particularly attractive, even for nerds like me who teach law. But there's also an exciting side to that, the EU Charter on Fundamental Rights, which could prove, I think, to be a very interesting thing, but it is a topic for another day. So, to conclude with just some thoughts from my own experience and to give some reflection, as I say, I did law with arts. I didn't do law as a kind of a pure undergrad degree. And then I did the bar, and one of the things when we did the bar was we were told to forget everything that we did in university, which is an odd thing to say to people who are entering into a career where negligence might be a problem. Because some of what they taught us in university was actually right, I found out. And then I became, very accidentally, an academic. And one of my colleagues, when I originally started as an academic, he said, you have to use the revolving door, which was a different metaphor at that time, but it applies in a non-criminal context as well. And I left in 1999 to become the first full-time director of the Irish Council for Civil Liberties, which was an organisation founded by Mary Robinson, Cad Rasmal and Donald Barrington in the 1970s. But it didn't actually have a full-time director, because this was a mark of how voluntary a lot of the work was until the late 1990s, thanks to the funding of Chuck Feeney. And I went to work in that organisation. It was essentially a campaigning organisation. I was 31 when I got the job. I really hadn't a clue of, obviously all the other candidates were dreadful, and I hadn't a clue what I was actually doing. But I learned on the job, and then came back to the university here in 2002, got involved in a number of EU networks and joined the boards of organisations, other NGOs, which was a really fascinating perspective. So I was on the board of Amnesty, the board of FLAC, and later on the board of Interrights, a London-based litigation organisation, which was a really, really fascinating experience, but it no longer exists. And then I got involved with state bodies, the Legal Aid Board, the Law Reform Commission, and most recently the Commission on the Future of Policing in Ireland. So it's been an interesting journey in the sense that the certainties that I knew when I worked in the NGO sector, I've had some chance to promote on, in state bodies, not particularly, I mean, they're, state bodies that aren't very core state bodies. It's a little bit more complicated from that side than it would be from the NGO side, but that experience is absolutely invaluable. And to see, to give you an example, when we were finishing the report of the Commission on the Future of Policing, Noeline Blackwell and I, who was also a member of the Commission, weren't particularly happy with all of the human rights elements in it. So we undertook to human rights proof it. And Noeline said she was experienced at this from her time in Amnesty, when Amnesty became interested in women's rights, which Niamh has mentioned, because she used to go through the documents and write "and women" at the end of every sentence. And so we spent a night writing "and human rights," and our serious approach to human rights, all these kind of words. We got excited later in the night and started using adjectives. And but the report, when we did that exercise in human rights proofing, we had in our other hand an excellent report by the Irish Council for Civil Liberties that had commissioned the report independently from a woman in Northern Ireland, Alison Kilpatrick, who did a really good authoritative piece of work. So there was actual real impact in action in the doing of that, and you could see this circle closing somewhat. So what I've learned from reflecting on all of this is that there are multiple pathways to impact, not just one. And it's a really important lesson, I think, for lawyers to understand, because the lawyer can focus in on the one impact, which might be a litigation impact. Law is essentially a literacy that, if you're working in the human rights world, it's a particularly valuable language, but it's not the only one. The richness is largely actually in the collaborations with others who are not lawyers. And throughout all of my involvements, I've always been a teacher. And I think one of the great things about teaching is that it affords you something which should be central to all practice, which is to be reflective, to think about what you're doing while you're doing it, not too long after you've done it, but you have to do that too. And if you do that in everything, I think whether it's advocacy or whether it's lawyering generally or just teaching, I think it will be better. And that's the kind of simple message that I have from my own reflection. Thank you.
Thank you very much, Professor O'Connell. I don't think anybody in this audience will say that he hasn't a clue. He's there's great foresight in what education can do and for this upcoming generation. We now have a few minutes for questions and contributions from the audience. I'm not sure whether there's a roving mic. Do you want to? Are there any questions to? Please, there's this man in the audience there, on the right-hand side.
Will I speak loudly?
Please, yeah.
Given the damn report recently by the UN on Myanmar and the ethnic cleansing and genocide, do you think it's time now that Galway take away the freedom of its city from Aung San Suu Kyi?
I'm not sure whether that's a question for... We'll take a few questions. That's a good idea. Taking any other questions? We'll take 3 at a time.
Hello.
Thank you very much. This is a question for the GLAN speakers. I'm wondering if GLAN are taking on the appalling abuse of human rights of migrants locked up in terrible conditions within Libya, as well as in Turkey and Greece.
Is there a third question?
Can you hear me? Do you think there should be more structures of accountability in Ireland? And do you believe in the concept of enforced accountability?
I'm sorry, could you repeat that last part of the question?
Do you think there should be more structures of accountability in Ireland? And do you believe in the concept of enforced accountability? especially for state bodies and for people working for the state?
Right. A lot of these questions are more not necessarily directed towards advocacy. Would somebody like to field the first question about the city council? And it's not really an issue that arises in the context of advocacy, if you don't mind me saying so. It's a view that you have, and what can we're here to talk about the power of advocacy. I hear the point that you're making. Unless somebody wants to address it. You are advocating, yeah. I hear the point. I'm not too sure whether somebody wants to say that's a topic that we need to deal with now. Does anybody want to take that issue? I can understand the reluctance.
I would say that raising the debate and raising that question has a powerful effect.
Yes.
Geldof knew it when he was doing it. And it really, the outcome is irrelevant. It's the fact that this raises the question about what is happening there and why is she not acting. And it puts pressure on the political establishment to also act and to do their own advocating in their foreign policy. So I see it as the mere destabilization of her status as a form of advocacy that's quite powerful. It's transnational.
Thanks very much, Gearóid. Now, the second question, maybe Gerry will deal with this, about Lan. Why is it not dealing with Libya and Turkey?
Gearóid might answer that one as well.
Yeah. We are working on the issue of conditions of detention for a subset, particular category of migrant in Libya. Unfortunately, the action is linked to our existing case, and I can't say too much about it, but we have managed to smuggle out consent forms from these people from Libya to act on them. And it's extremely difficult. It comes with enormous responsibility, so I can't actually tell you more than that, but I'd be happy to, after this is over, to give you a bit more information on our broader plans on that issue. Yeah. But I mean, the Mediterranean basin, I think, is somewhere where we should be exercising acute scrutiny, especially when it comes to the criminalization of human rights defenders around the Mediterranean basin. Some of whom have been Irish educated, who've been locked up in Lesbos, accused of trafficking merely for helping migrants. A really pressing issue.
Thanks very much, Gearóid. Now, the last question was, if I understand it correctly, was do any of the panel want to talk about the structures of accountability in Ireland itself? Again, it seems to be a cause. Is that a particular cause that's very good? Thank you.
Yeah, I'll happily say a few things about that. I think that we desperately need a proper system of legal aid to use the European Convention on Human Rights Act here, because that is one very important way of holding state bodies to account for their obligations to act compatibly with all of the European Convention on Human Rights jurisprudence that we have now. And too often we just see things happen to people and they just cannot manage to take the case that they should be able to take. And having practiced in England and seen the huge amount of jurisprudence under the Human Rights Act there, the difference is incredible. I have a personal interest in the National Archives and the need to extend the remit of the National Archives to all of the non-state, private enterprise that provide public services. I think that dealing with the past abuse that I'm dealing with, I can see that the secrecy of information relating to services that the state was paying for is ongoing. I'm desperately trying to figure out a way to ensure that we have a national repository of all of the past administrative records, personal records, and witness testimony. But imagine the guarantee of non-repetition we could have if we actually could deal with the past at the same time as the future and actually amend the National Archives Act so that it brought within its remit all public provision records, i.e. every form of public provision that the state pays for, whether or not it's provided by a private actor. That would take care of what we need to know about the past, and it would ensure accountability in the future. And lastly, I would say that I think we have a problem with private inquiries. In Ireland, there is far too much privacy in the supposed truth-telling that we should be seeing where there's malfeasance in public office.
Donncha.
Yeah, just to supplement, I mean, I agree with what Maeve said, but there is, I was at a conference last Friday, which was really interesting. There is a public sector duty of compliance with human rights and equality principles under the Irish Human Rights and Equality Commission Act, but it doesn't create any private law cause of action. It can just simply be used in judicial review, and it's kind of intended as a kind of a soft law thing. But there is also, under the ECHR Act, which Maeve has mentioned, a performative obligation for organs of the state to behave in a manner that is convention compatible. And if they don't, you can get damages for that. And we were discussing this at the conference on Friday. And one of the ideas that emerged was that, well, if you can't take an action for breach of statutory duty for failure to comply with the statutory obligation, surely you can use the evidence of the failure to comply with the statutory obligation to sustain an action for breach of statutory duty under the ECHR Act. It's a bit technocratic for this time of the evening, but like there are things, there are actually lots of ways to make state bodies more accountable. But the one thing that absolutely doesn't work is setting up accountability mechanisms that are intended not to create accountability. And that's a huge problem. It's something that came across in the context of policing. And the multiplicity of oversight bodies, GSOC, inspectorate, authority, but they don't, as a combination, work. And we've made proposals for that to change so that they are in fact effective and that there is a very clear accountability line, and it's now over to the government to implement that. But these aren't accidents. They happen as reactions to things, so there's a certain imperfection, but sometimes it's designed. Sometimes they're actually intended not to create a proper oversight mechanism, and that is deeply problematic, because it takes about 10 years to figure out that it hasn't worked before you go on to make it work possibly the second time. And I think we really have to cop on about that, and I think politicians have to become much more exacting about legislation to establish these kind of entities. They can't just usher them through and say, well, this is going to work, this is going to be a great thing, it's better than what we had before. You actually have to examine that very critically and not do that. So that's, I think, one of the things. There is a real responsibility there. Parliamentary accountability doesn't really work. Hauling people before parliamentary committees has a certain kind of an impact, but it doesn't really embed change. Whereas those kind of bodies that are established to ensure that do work if they're established properly.
Can I just refocus a little bit, and thank you very much for those comments. On the question of advocacy, I'm just going to ask one question to Dr. Robinson in particular. Just as a lawyer, having been an advocate, how does she and how has she coped during her career with recognizing the anger? She touched upon it, and that she might feel, and then be the true advocate and pick the fight you want to fight. That's one question, and I take two other questions because we're just going over time, and I did promise you that and there's two gentlemen here, down here, and there. Sorry, we'll
Sorry. If I could address just an issue that was brought up there by Dr. Maeve O'Rourke. You mentioned about the kind of the secrecy provision under the Commission Investigation Act. There's an exact same provision under the Human Rights and Equality Act where they can perform investigations. In my view, it's clearly both unconstitutional and a violation of Article 10. So you have a Human Rights Act that violates human rights law. I'm just wondering if there's anyone who's willing to challenge that, because there's clear case law from the ECHR court that says you can't put prior restraint on speech. And people who have a right who have access to information that they bring to an investigative body should be entitled to publish it elsewhere. While it's understandable they may not have the cloak of privilege that would attach, they should be allowed to still publish it under their own auspices.
So your question really is,
well, is
there what?
Surely, is it not evident that there's a very low level? It's very difficult to advocate in Ireland because it's the persons who are going to be affected by that are not going to be financially motivated to take on the legal system. So you need to have a kind of a public interest advocacy system that can litigate those type of issues.
So should we have a public interest advocacy system? Thanks.
Yeah.
Okay. I'm just going to take two more questions down here. Sorry, just down here. Thanks.
Okay. My question is regards to, I guess, keeping people engaged in advocacy. Like there was such a huge mass mobilization around the repeal referendum this year. And I suppose I found personally that if an issue affects someone, they'll be a lot more likely to be engaged. So I guess it's how to keep people engaged in issues that are international or not necessarily affecting their lives, and how to keep advocacy going in that respect.
Very good, thank you. Last question then.
My question is to Dr. Mary. I'm a little bit concerned about the next generation. I mean, you've done so much for your generation and it's picking up to now. Are there plans on your part to provide mentorship support to the next generation, upcoming generation, telling them about your pitfalls, some challenges you encounter, and now you're able to navigate those challenges to get to where you are today? Thank you.
I think the question is that are there signals that she can give, and are there steps that she will advise? Is that correct for the next generation? Thank you. So the first question, whichever way, Dr. Robinson, you wish to deal with them.
Well, I think you've given me an opening to plug my book.
I'll let you stand up
The reason I say this is the book begins with me coping with a heavy moment of anger in Marrakesh at a climate conference in 2016, in November 2016. Do you remember what happened in November 2016, on the 8th of November, 9th of November? And I was so angry that we would be having a climate conference and that in the United States you had an election of a president who was going to had announced during the campaign that he didn't believe in climate change, that it was a Chinese hoax or something, and that he was going to pull the United States out. He said it several times. And so I arrived in Marrakesh and, had a troubled night, and I described this at the opening of the book, and then I said, I'm going to have to make a statement tomorrow. And, I kind of felt, I'm a former president. I was actually elected, what number of years was it? 26 years, I think it was, on the same day as President Trump. Let's see what. Anyway, it doesn't matter. It was the same day, whatever number of years it was, and I was dissuaded by somebody who has given me a lot of good advice in my time. One Bride Rosny, my special advisor when I was president, still a very dear friend, and she said, "No, Mary, don't just make a statement like that. Get a reporter to ask you the right question." Very, very good advice. And I got the reporter to ask me the right question. And maybe I could just answer the two other questions that I thought I would have something to offer on them. The question asked about keeping people engaged in advocacy. That is why I wrote this book, so that people would become engaged in the existential threat facing us. And they do it because they'd have more empathy and more sense of solidarity with people already suffering from climate change. So in this book, it's a book of stories, but they're real life stories, 11 of them, and 9 of them involve women, but the 2 men are also interesting. And, and the point is that they're stories of hope, resilience, and the fight for sustainable development. And I honestly think we need to hear these stories. We need to know what people are doing when their whole lives are being devastated and they get active. And then we need to realize we all need to take this personally now. That's the point. We all need to take it personally and decide we're going to make a difference. And I think on the sort of idea of the mentorship, I mean, I'm trying to get across the approach that if you start taking it personally, as I am doing, and trying to create good habits, I've become a pescatarian. What's the vegetation? You eat fish. Pescatarian. No, not pescatarian. Is it?
Presbyterian.
Anyway, I don't eat meat anymore. I only eat fish. But the point is, I'm trying to show that we've got to take steps at all levels, including in our own lives, in our own homes, in our schools, in everything. And then, if we do that, this is the point. If you start doing that because you're taking seriously what's happening, then you use your voice and your vote. And then you hold your government accountable. And it's governments that we need to take the measures that will ensure that we have a safe world for our children and grandchildren. So I'm not sure after what I said about, I wrote this personally. It's not really the work of my foundation. So I can say that this is my advocacy for the future. Thank you very much.